Good morning. Today is February 15th, 2024. This is the matter of a combined application Z0346-23-ZAP, an application for a zone change, and secondly, a combined application for Z0347-23-SL, a related application for a subdivision dependent upon approval of the zoning change. My name is Carl Cox. I'm a private attorney appointed by the Clackamas County Board of Commissioners as hearings officer with authority to conduct this hearing and make a determination in this matter. I will state a few important things for the record. First, I've not received any ex parte contact, meaning no one contacted me outside of these proceedings to try to persuade me concerning a fact or issue present in this matter. I did receive a staff report and exhibits, including an exhibit list, and it was added to this morning. I was able to skim through the last exhibit that was added this morning, but I honestly haven't finished. It was pretty detailed. So exhibits 1 through 65. I've also considered issues of bias and conflict of interest and have determined that I do not have any bias or conflict of interest in this matter. The county is making a record. That record is available through the county. This is a quasi-judicial land use hearing, which means two important things for those participating in this hearing. First, all of the criteria that can be used in reaching a decision have been identified in the staff report. Testimony, arguments, and evidence must be directed towards the criteria identified in the staff report or other relevant criteria found in the comprehensive plan or other land use regulation that the person believes applies to the decision. Accordingly, please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Oregon Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Once final, this decision may be appealed to the Land Use Board of Appeals, the Oregon Land Use Board of Appeals. At this time, I'm going to ask that the county provide an explanation concerning participation in this hearing via the Zoom platform.
Thank you. This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, have both audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature. Attendees on PC and iPad, you have a raise hand button on the Zoom bar, which is the top or bottom, depending on device. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Be sure to provide your name and mailing address when you begin. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of the hearing and you wish to submit additional written testimony, email written testimony to bblessing@clackamas.us or mfritzy@clackamas.us or mail it to Clackamas County Planning and Zoning Division, 150 Beaver Creek Road, Oregon City, Oregon 97045. The staff contact email address is available on the webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearings officer's written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address by email to the staff contact for the application or by entering it in the Zoom chat function during the hearing. Thank you.
Thank you. The order of proceedings will be that I will ask the county to begin the hearing by presenting the staff report. Each of the county planners has submitted to me an exhibit showing the county's presentation, so I'm going to ask that the county begin with that. There will be an opportunity for the applicant as well to submit evidence, testimony that the applicant wants me to consider with respect to each of these applications. Then I will provide an opportunity for members of the public to provide public comments and testimony that members of the public want me to consider. Approximately how many members of the general public are present this morning?
It looks like 13.
13, okay. So there are a substantial number of people, and I want to make sure that I receive comments from everyone who wants to participate this morning. If there is not enough time for you to state all of your commentary, as Mr. Blessing noted, the record will be open at a minimum until 4 p.m. today. So if you're not able to finish your testimony, I'm anticipating being able to provide everyone that wants to participate this morning at least 3 to 4 minutes to make their comments and have them considered. But if that's not enough time for you, please submit your testimony in a written format to the county as Mr. Blessing indicated, and I will receive it as an exhibit in that way. At this time, I'd like to ask that, and before I close the record, I will provide an opportunity for any member of the audience to request that the record stay open longer than that. At this time, I'm asking that the county proceed with the county staff report, please.
Thank you. Hi, I'm Martha Fritzy with the county's Planning and Zoning Division, and I'm going to start out this morning. All right. Can you see?
Yes.
All right, excellent. So I'm going to start out and talk about the zone change, and then hand it off to Ben Blessing, who's going to talk, about the subdivision. So specifically, actually, before I get started, I just want to acknowledge that we have received a very large number of comments from the public, which is wonderful. They have all been entered into the record. They have all been sent to the hearings officer. The particular property is within the hamlet of Beaver Creek Community Planning Organization area. We've received some testimony from them. And also, we received some new exhibits that got forwarded to the hearings officer after the staff report and the first batch were posted. What's missing here is, of course, the piece of testimony that Mr. Cox alluded to earlier that we received this morning that has been entered into the record. I just didn't update my PowerPoint. So everything that was submitted has been read, entered into the record, and forwarded to the hearings officer for consideration. So regarding the zone change, specifically the proposal includes a proposed zone change from the Rural Residential Farm Forest, or RRFF5 zoning district, to the Rural Area Residential 2-acre, or RA2 zoning district. It is notable that in this case, it is only the zoning district that is changing. Both of these zoning districts implement the same comprehensive plan designation. And so that's why we are only talking about a change from one zone to another. The zone change itself doesn't authorize any development. Essentially, what it would be doing is increasing the development potential from 11 lots under the RFF5 zone to 28 lots, or up to 28 lots under the RA2 zone. Although the second application that was submitted concurrent with this would authorize development for 28 lot subdivision, and that's what Ben is going to talk to you about. Little background: this property is just over 56 acres. It's on the corner of South Beaver Creek Road and South Wilson Road, about half a mile south of the city of Oregon City and the Metro Urban Growth Boundary, a little bit under a mile north of the unincorporated community of Beaver Creek. This is an aerial showing the subject property and development. You can see development around the subject property is largely residential. A lot of it is smaller lot rural residential. There's a church in sort of northeast of the property, farm immediately east of the property. The site itself is relatively flat. There are no protected waterways, wetlands, habitat, or known hazard areas. There was a wetland delineation done for this property because there's a small draw that or ditch that it was identified as potentially being a wetland. At the wetland delineation found that it was not, it could not be classified as a wetland. Notice was sent to DSL, to the Department of State Lands, and they've concurred that there are no jurisdictional waters and no wetlands on the property. The property itself is developed right now with one single family home and some outbuildings. It's an old farm property. It doesn't appear to currently be farmed. It has been sort of described as containing some trees and overgrown vegetation. So despite some of the different uses in the surrounding area, I mean, the immediately surrounding area is all zoned rural residential. Immediately east, south, west of this property is zoned RRFF5. And then immediately north in the orange is zoned RA2. And also it's notable that the area, all of that area north of the property between the subject property and the metro urban growth boundary is also in an urban reserve, in an area that is set aside for Metro and the city to pick from at some point in time in the future to potentially expand the urban growth boundary if there's a need to do so. So there are a lot of relevant policies and criteria related to zone changes, including various statewide planning goals, various comprehensive plan goals and policies, and zoning and development ordinance standards. These are all discussed in detail in the staff report that was included as Exhibit 1. I am going to hopefully fairly quickly touch on the highlights and sort of some of the more relevant criteria related to this zone change. And so I'm going to start with statewide planning goals. In the rural residential area, the first thing that needs to be looked at is whether or not an exception needs to be taken to specifically to goal 14, urbanization. And there's really two pieces to this analysis. The first piece is related to the specific rules under the Oregon administrative rules that provide direction about whether an exception to goal 14 is needed for rural residential land specifically. The second part of this rule really has to do with whether or not what the proposal is constitutes urban or rural development. And so there are two pieces that need to be analyzed in order to understand whether or not a goal exception is needed for a particular zone change. And so this gets sort of a little technical. And again, I'm going to try to sort of get through this fairly quickly, but I'm happy to answer any questions anyone might have. The first piece, specifically the Oregon administrative rules, under 660 Division 4, 0040, which is specifically the application of statewide planning goal 14 to rural residential areas. It includes some general policies like requiring a minimum lot size of 2 acres. It acknowledges also that some jurisdictions in Clackamas County is one of these, was already acknowledged to comply with goal 14 when some of these rules changed in 2000. And so that limited the amount of work that the county had to do at the time in order to show that they were still in compliance with goal 14. But then it also identifies when an exception to goal 14 is required for any change in the local government's requirements for minimum lot or parcel sizes in rural residential areas. And that specific rule that is noted in that last bullet is really what a lot of the discussion is about, because there are varying interpretations of this rule. And it's listed up here. I'm not going to read the entire thing, but this rule changed in October of 2000, and essentially there's two differing interpretations. Although the county has done county staff and county council have done some research on this, and based on a case Luba case out of Curry County, the Clackamas County and the hearings office, the past hearings officer decisions, and the county council have come to the conclusion that what this rule means is that the Goal 14 exception is not always required, not in every single case, for a rural residential zone change. And that in the particular case of the way that Clackamas County's rules are and have been structured, this sort of carve-out situation that Luba created for Curry County in that 2007 case also applies to Clackamas County, largely because the county was acknowledged to comply with Goal 14 prior to 2000, and also because the Clackamas County's processes and criteria to change zones and minimum lot sizes within the rural designation haven't changed since then. And the way that our zone changes, like in rural residential areas or structures, are really not functionally or substantively different than Curry County's. The State Department of Land Conservation and Development, or DLCD, submitted some comments. They're found in Exhibit 15. The state asserts that that is not true, that the Goal 14 exception is required, and that they don't believe that this situation discussed in that 2007 case really applies to Clackamas County, and that the Clackamas County's rural residential zoning is just structured differently than Curry County's, and therefore it doesn't apply. This is not the first time we've had this conversation with DLCD. And so there was a previous approval that the county, there's a previous zone change that the county approved, and DLCD has appealed that zone change, and that's currently at Luba. We don't know what the status of that is at this point. And so in its testimony, DLCD has requested that the county delay the decision, although staff, through reading the testimony and the applicant's testimony, really found that DLCD hadn't really provided any additional information that would lead or compel staff to sort of reassess county's position. And so it is still our position that a Goal 14 exception is not required under this specific provision. That was a lot, but the second piece of this is a little bit easier and more intuitive. This has to do with whether or not what is proposed is a rural or an urban use. And I say it's a little more intuitive. It may not be for some people in the room, because according to Goal 14, rural residential lands actually can be considered urban or rural. It's not strictly the line between the urban growth boundary, inside and outside the urban growth boundary, how a lot of us historically have thought about this. The rule specifically identifies 1 acre lots as urban and 10 acre lots as rural, but there's really no bright line in between for the lot sizes in between, and we're talking about 2 acre lots. And so based on past decisions, there's a number of factors that can be considered when determining whether or not a use is urban or rural, including the provision of public facilities and services, looking at potential impacts to nearby urban growth boundaries and its ability to continue to function appropriately, whether or not the use is appropriate for or limited to the needs of the rural area, and the use intensity. So in its testimony, DLCD raised the issue about urban and rural uses and suggests maybe this use is urban, identifying factors such as the fact that it would be connecting to public water service, that it's in the Oregon City School District, and its proximity specifically to the urban reserve. Staff looked at this and looked at the particular situation of this property, the location, the applicant materials, and found that based on these factors, the use really is still rural. Simply being in a public water district doesn't make a use urban. And if you looked at the map of the service area of Clackamas River Water, which is the public water district here, it includes a large portion of the rural area. Same thing with the Oregon City School District. It is not simply an urban school district. It is definitely both an urban and rural school district. And This property certainly is close to an urban reserve. It's adjacent to the urban reserve, but there's, this property is not in the urban reserve. And so there's no reason to believe that this property, there's no way to assess whether or not this property would have an impact on the UGB's ability to function if the city and Metro decided to move into that urban reserve, because that urban reserve is really intended to be like a 50-year look. And so there's no particular timeline or any specific plans at this point to move into the urban rural reserve. And the fact of the matter is a lot of the land that's in the urban reserve already is zoned RA2. And so staff really found that there's no compelling reason to believe that another property that's zoned RA2 would be somehow viewed differently with respect to the urban growth boundary's ability to function. And so under this factor, urban and rural, whether or not the proposal is urban or rural, staff found that this is indeed a rural use, and so no Goal 14 exception is warranted under either of the analyses. So then we move on to Goal 11. This is another issue that had been brought up in DLCD's letter, and Goal 11 relates specifically to public facilities and services, and what was identified and is worth some discussion really relates to public water. And so the administrative rules related to Goal 11 specify that outside of urban growth boundaries and unincorporated communities, local jurisdictions shall not allow an increase in base density or higher density or increase the allowable density solely based on the provision of water. Admittedly, these rules are a little confusing. It's sort of three ways of almost saying the same thing. I think that based on staff's research and based also on DLCD's comments, essentially the interpretation is a local jurisdiction cannot approve a higher density if they couldn't also approve that higher density without the provision of public water. And so it doesn't necessarily say you can't use that as a factor or as one of your criteria, as the county does, but you do have to demonstrate that that the same number of lots could have been developed if it wasn't going to connect to public water. And in this case, it would be using wells. And so this is discussed in the staff report. The applicant's attorney has submitted some additional findings in Exhibit 62 related to Goal 11. The short version is that the county finds that there's the property, the 2-acre lots, are typically found in the rural area and are often, there's no reason to believe that these could not be developed with both septic and water. Shared wells could be used. The 2 acres is historically a large enough lot in other areas of the urban area, the rural area, to develop with both well and septic. And this particular property is not located within any sort of limited groundwater limited area where the state would limit the number of wells. And so staff has found that the upzoning is not inconsistent, would not be inconsistent with Goal 11 in that respect. And the fact of the matter is there is a requirement in the RA2 zone for public water service to be available. There's not a requirement that it be used necessarily, but it does need to be available. And that factor in our comprehensive plan really is a limiting factor. It limits the geography and where this type of zone change could occur because there's not a lot of areas outside the urban area that have public water, although there is a large area outside of Oregon City that does. And then the final piece of DLCD's comments were an assertion that a Goal 11 exception is needed, but that seems to be tied really to the fact that they think this might be an urban use. And so if this is not an urban use and not using urban services, then a Goal 11 exception would not be needed. So that was a lot of words to really come to the conclusion that this proposal does not need a goal exception to Goal 14 or Goal 11. And so once we Once we establish that, we then move on to really what are the zone change criteria listed in the county's comprehensive plan and zoning and development ordinance. In the ZDO, section 1202 identifies the specific criteria that needs to be assessed for zone change. There's really 4 main criteria. The first one doesn't mean they're small criteria, but there's 4 main criteria. The first one is that the proposed zone change has to be consistent with the applicable goals and policies of the comprehensive plan. This involves quite a bit of analysis. I can say that both the applicant and the staff have provided findings in detail in the staff report and the application. Basically, chapters 12 and 11 were found to comply, but these really have to do with procedure and coordination policies, which have been followed in this application. Chapter 5 is the transportation system plan for the county. There's one policy in there that specifies a zone change must comply with the transportation planning rule or statewide planning goal 12. Every zone change has to comply with the transportation planning rule. And so the applicant has provided a traffic impact study. The county's transportation engineering staff have reviewed that study. The City of Oregon City provided some comments related to that study, specifically requesting some additional intersections be included in that study, and particularly the intersection of Beaver Creek Road and Highway 213, and also Highway 213 and Redland Road, which are some intersections inside of the city that are known to have some congestion problems. Transportation engineering staff did review for a second time the study area and explain the methodology and why those intersections were not included. And that's in Exhibit 59. And they are in the room and maybe can elaborate on that if there are some questions about it. And transportation engineering staff also found that the proposal could comply with the transportation planning rule, but some mitigation was needed. And I'll talk about that in just a minute. Under Chapter 4 of the comprehensive plan, that's the land use chapter, and that's really where we find sort of the meat of the criteria for a zone change, and specifically for what areas can qualify for the RA2 zone are in policies 4.11.1. There are 5 primary criteria for the RA2 zone listed here. I'm going to talk about them in just a couple of groups. The first 2 being that parcels are generally 2 acres or smaller and the area is significantly affected by development. Based on some past Board of County Commissioners interpretations of those particular policies, the board has directs applicants to look within a quarter mile of the subject site. And it really just means that the simple majority of the lots are 2 acres or smaller. The applicant did provide an analysis of those lots and found that almost 78% of the parcels within that quarter mile are less than 2 acres. And in fact, nearly all of those 2 acre parcels or less than 2 acre parcels are also developed. I think it was apparent from the aerial photo that there is other development in the area. There are in fact a lot of other rural residential subdivisions that have lots that are only half an acre in size. There's the church adjacent to this property, and there's also the proximity to both the city and the unincorporated community and all of the associated development in those areas. And then the last 3 that I've kind of lumped together talk about the presence of no natural hazards, topography and soils, requires a public or private community water system to be available, and requires that the property be within proximity or adjacent to an unincorporated community or an incorporated city. As was mentioned, there's no hazard areas, no wetlands, no streams, no floodplain, no map landslides, steep slopes. The soil types are appropriate for development, and the site is itself relatively flat. It's located less than a mile from both the City of Oregon City and the unincorporated community of Beaver Creek. There is no interpretation or strict definition of proximity. And so in the past, decisions have considered less than a mile to be proximate, but there is really there's no hard and fast line on that. It is also easily accessible to both of those communities via a major arterial along Beaver Creek Road. And so staff finds that under this first criteria for the zone change, that this proposal is consistent with all of the relevant comprehensive plan policies. Part B, the second criteria, is a whole lot easier. It just requires that any public services that are needed requires demonstration that there is sufficient capacity to serve whatever the development would be. In this case, there is no public sewer. This is outside the urban growth boundary, but there is public water. And so preliminary statements of feasibility have been provided by both the surface water management and the water service districts in this case, stating that it could be served sufficiently. And then the last two criteria under the zoning and development ordinance really have to do with the transportation system. The first one being that the transportation system is adequate and will remain adequate, and the second one being that the safety of the transportation system is adequate and will remain adequate. And so I noted that a transportation study was provided by the applicant, and transportation engineering staff did confirm that with mitigation, both the adequacy and safety standards could be met, and recommended two improvements be constructed in order to meet this standard. And those two are a southbound left turn lane on South Beaver Creek on the approach to the intersection with South Wilson Road, and also realignment of that particular intersection, and have identified, based on their statements in the record, that these are this is needed mitigation in order to meet these criteria. And so I'm going to wrap it up. Finally, staff has found that the proposal does not need an exception to statewide planning goals 11 or 14, and that with conditions, the proposal meets all the applicable zone change criteria and has recommended approval of the zone change from RFF5 to RA2, subject to those conditions, which essentially are those two transportation system improvements.
Thank you.
And that is it for me. I'm going to let Ben talk.
Okay. Mr.
All right,
Bless.
okay. One quick second here. All right. My name is Ben Blessing, Senior Planner with Clackamas County Planning and Zoning Division. This is the subdivision portion of the submittal application Z0347-23. So I'll do just a quick, again, overview of the vicinity. There's Martha Fritzy did a great job of covering the kind of the details, particularly the vicinity. So there's just a quick look at the topo and the surrounding area and vicinity. So again, aerial view, again confirming no hazards on site, no environmental areas. Applicant's wetland study confirmed that the shallow draw here kind of in the center of the lot didn't have any wetlands. So you got a relatively flat site as far as natural hazards and environmental concerns. So just some of the subdivision highlights. So again, each new lot has to be at least 2 acres. The applicant's site plan shows lots being at 2 acres more or less, but again, at the final plat stage, each new lot has to be 2 acres or more, rather. So that is a condition of approval. Each new lot will be on an individual septic system, and they will be a private road serving each of the lots. So that's a 30-foot wide easement containing basically a private road, and the main portion of the road will be pavement, and some of the smaller or the other 2 roads that serve some of the other lots that are less than 10 will be gravel. Drinking water is provided by Clackamas River Water. Each new lot will have separate meters. And stormwater, of course, will be reviewed by County Engineering Division through the county stormwater standards. So just a quick overview of the subdivision plan. You have lots 1 to 28, fairly straightforward, 2-acre lots, private road. On the next slide, I'll go over some of the public road improvements. And again, Martha Fritzie already mentioned some of the requirements that'll be needed there. But fairly straightforward. Clackamas County, or Clackamas Fire District rather, may require an emergency access onto Beaver Creek. That will not be direct access. All the actual access coming in and out of the subdivision will go onto Wilson Road, there again on that private easement. So the public roadway highlights. So this is basically following our comprehensive plan and the rural arterial standards for Beaver Creek. It's just half street improvements. So there'll have to be a roadside ditch and some just basically there may be improvements to the road itself. And as for Wilson Road, that is a local road, and same thing, just full half street improvements on that side. There also will be a dedication, public road dedication to meet the minimum street width, which I believe is 4 feet. I should also note we do have Clackamas County Development Engineering staff with us as needed, and Ken Kent and I believe Christian Snuffin with traffic engineering, so they can help if there's questions on some of the specifics of the roadway standards. The two requirements that Martha Fritzie mentioned before, the south for the public roadway improvements is southbound left-hand turn lane required on Beaver Creek Road. That's in the conditions of approval. And then of course there's a realignment of Wilson Road at the Beaver Creek intersection to meet as close to a 90-degree intersection as possible. And there again, that emergency fire access may be required on South Beaver Creek Road. So those are the highlights. It's a recommendation is approval subject to conditions, and again, contingent upon approval of the zone change request with Z0346-23. And that is all I have. Thank you.
Thank you. At this time, I'd like to provide an opportunity for the applicant to add supplemental testimony or comments that the applicant wants me to consider.
Was the transportation planning folks at Clackamas County going to talk about those road improvements?
Well, if I could, I believe they're there for questions, but I don't think we had there's not generally a plan for them to present, but unless anybody else has a different understanding.
If they do speak, we'd like an opportunity to rebut their testimony.
On what subject?
The transportation mitigation package that they've requested.
Okay, on the two conditions of approval, is the applicant contesting the proposed conditions of approval?
One of them, yes. We're fine with the dedicated left-hand turn lane. We do believe that the road realignment criteria violates constitutional standards as discussed in Nolan and Dolan.
Okay, well, let's based on your comment here, I don't think it's necessary that we have commentary on the frontage dedication, your improvements, excuse me, but you want to discuss the proposed condition of approval with respect to that realignment. So let's have some testimony about why that's required by the county.
All right, so I think in this case, Ken Kent or Christian, do you want to kind of explain the roadway standards, the safety aspects? Is that possible?
I suppose I could speak to that, unless Ken, do you want to? I'll go ahead. I'm Christian Snuffin, Senior Traffic Engineer with Clackamas County Department of Transportation and Development. The concern is the realignment of Wilson Road and its current skewed intersection with Beaver Creek Road. This is a safety issue. The issues with skewed intersections is there are many concerns here. They generally result in larger intersections requiring the drivers have a longer distance to travel when crossing or making turning movements, which increases their exposure in the intersection. The orientation of crossing traffic to the waiting driver may make it difficult to detect and judge the speed of approaching vehicles on conflicting paths. Skewed intersections are more difficult for large trucks to navigate. Acute angles can introduce additional sight obstructions, including possible obstructions from the body of the driver's vehicle. These are the side front pillars that obstruct visibility. Additionally, many older drivers have difficulty with physically turning their heads, necks, or upper bodies as required to obtain the needed sight lines. So those are generally the overall concerns. With this development, it's going to increase traffic on Wilson Road by approximately 66% over existing traffic volumes. So there is a significant increase in traffic at that intersection. And that's a overall summary.
Just a minute. So you
Sure.
stated that you're anticipating a 66% increase in traffic if this subdivision were constructed as proposed, correct?
Yes, that's according to the traffic impact study submitted by the applicant.
Okay, so just a moment here, per applicant's TIS. And did you do a proportionality study, what the cost versus what was the analysis that resulted in requiring this condition, this improvement?
We haven't done a direct proportionality study that I'm aware of, but the impacts are significant.
How much property do you know is involved here? I'm assuming what you're talking about is requiring the applicant to realign across a portion of the existing parcel, correct?
That's correct.
Okay, so moving the road over is what you're.
Yeah, realigning it to as close as 90 degrees as possible to bring it in compliance to our roadway standards section. What section is that?
I can add section 250.8.2
Thank you, Ken.
basically spells out that intersection should be as close to 90 degrees as possible with some variance of to 85 degrees is kind of within the range, but generally at 90 degrees. And I can add with realigning this intersection, our standards in the roadway standards provide for about what is a 50-foot length, tangent length at approximately 90 degrees. And then there would be horizontal curves to tie the road back in. So, and a realignment would anticipate, some shift in the road into the project site in order to beat those curves and provide that loose 90-degree tangent with Wilson Road.
You're cutting in and out a little bit. Can you restate what you said?
Sure. So our standards for 90-degree intersection include a tangent that's 50 feet in length approximately. And then that would require curving the road back into its current. And so that's good. That would involve some extension of the right-of-way and roadway into the current project site. So additional dedication beyond what's currently required to meet the standard cross-section.
Okay. Thank you. Is that what the county has in support of the condition of approval, or? Sir.
So I'll certainly speak to the subdivision aspect. The criteria was stated. I can provide that from section 1007, but basically to comply with the roadway standards, that's what traffic engineering and development engineering is recommended. I don't know if this is appropriate to talk about that issue of proportionality and kind of or the county's take on that at this point. I mean, I was going to recommend that, if proportionality needs to be reviewed, the county would certainly want to review that, and probably leave the record open for that before, we would like to, essentially provide feedback on that if possible, if that's going to be in question. But to answer your question, the ZDO criteria in the subdivision basically supports that it comply with the roadway standards, and they've cited the applicable roadway standards, and that's why the condition was opposed.
Sure. Did the applicant indicate to you that they were contesting that condition of approval?
No.
And my comment to the applicant is, it's difficult to bring this issue up, directly at the hearing, and I'll certainly consider the applicants contesting this part, but it will likely, as Mr. Blessing just stated, require leaving the record open to have additional material submitted and a rebuttal period and a last word period, and it will extend this timeline, or not the timeline for the final decision, but I mean extend this process quite a bit, when the applicant certainly could have addressed this in advance of the hearing and had this worked out. So that's my comment about this raising the issue for the first time at the public hearing. At this time, what would the applicant like to add in rebuttal or of the condition?
So, Mr. Hearings Officer, just to be clear, we didn't know about the road realignment until we read the staff report 7 days ago. We did immediately schedule a meeting with staff to kind of flesh out those issues. And I think we had that meeting, 2 days ago, I think? Yes. So, this is kind of a late breaking issue that we weren't really cognizant of until fairly recently. Our traffic engineer did not recommend a road realignment. So a couple things there. Let me just go ahead and talk about it.
Let's go back and can I get you to state your name and your representation for the record?
Yeah, my name's Andrew Stamp. I'm a lawyer at Val Fotheringham. I've been a land use attorney for 25 years. I'm also a land use hearings officer for various jurisdictions. So we will address that in writing, and we agree that's appropriate. We do think that the proportionality is the burden of proof of the county to submit. We do think whether or not they have a legislative code standard that requires that improvement is irrelevant to the constitutional analysis. Although I will say that the standard that was cited, 258-2 of the road standards, is not written in mandatory terms. It basically says as close to 90 degrees as possible. LUBA views that as aspirational words that does not constitute a mandatory approval standard. So I question whether that standard can even be used as a basis to impose the condition. Although I would say we're not necessarily saying that there isn't some safety improvement that could be had by having such an improvement. With regards to the 66% increase in traffic on Wilson Road, that's also irrelevant. The more appropriate standard is to note that it's 3% of increase in traffic on Beaver Creek Road. So the conflict would not occur on Wilson. The conflict, to the extent it exists, would cause a crash on Beaver Creek, and therefore Beaver Creek is the appropriate road to consider traffic volumes. I also question whether or not there's any relevance to the fact that we're adding any trips to the system, because frankly it's an existing problem, and you know, that intersection is, the reason for the problem is the intersection doesn't connect with Beaver Creek at a 90-degree angle. It's what, closer to a 60-degree angle or 50-degree angle, something like that. That's an existing problem. And to the extent it creates a safety problem, it's not a problem that we created or a problem that we exacerbate. So we don't think there's any nexus at all. But even if there is, there's definitely no rough proportionality there. Even if you assume 66% as your number, they've tagged us with 100% of the cost. So there's no proportionality between 66 and 100. But the real number that should be used is 3%. And I don't even think there's a direct correlation between the amount of increased traffic that we would add and any increased degree of safety problems. That's not a direct one-for-one correlation. That's not how statistics work. So anyway, that's really all I want to say about that now. We will address it in writing. I've already started to work on a letter, but I haven't been able to finish it, where I will address these constitutional issues in detail. And I hope to have that by the next open record period. I would expect to see the county's rough proportionality findings during the first open record period, so that I would have a chance to rebut during the second. So with that, I think, unless there's any questions on behalf of the hearing officer, we would just prefer to just put that issue aside for now and move on with the rest of our presentation.
Same. Let's go ahead with the rest of your presentation.
Okay, great. Thank you.
Thank you.
Alrighty. Good morning, and thank you for your time. For your consideration today is the Mann Brothers Estate Zone Change and Subdivision, Clackamas County Land Use File Z0346-23 and Z0347-23. My name is Marie Holliday with AKS Engineering, and for the record, my address is 12965 Southwest Herman Road, Suite 100, Tualatin, Oregon 97062. This project was a culmination of efforts on behalf of the applicant. Again, my name is Marie with AKS Engineering, and our firm provided the land use planning, civil engineering, surveying, and other services for the project. Lancaster Mobley provided the traffic consultation services for the project, including the transportation impact study and the transportation planning rule analysis. And you just briefly heard from Andrew Stamp, the applicant's legal counsel with Vile Fotheringham LLP. And as we just covered, the applicant requests to leave the record open for 7 days, and we will discuss this further at the tail end of our presentation.
For at least 7 days.
We'll have a discussion about that.
Okay.
Okay.
Staff's presentation was thorough, so I'll try and stay brief. You can see the property is shown with a purple overlay. The address 20750 South Beaver Creek Road in unincorporated Clackamas County. The site is about 56 gross acres, and this project involves a zone change and subdivision application. These applications should be reviewed through this type 3 procedure, which include a staff recommendation, in this case, approval of both applications, and a hearings officer decision before you. Again, on the screen is the subject site, and you can see here in the northwest corner of the site, there's a white boundary here. There's an existing home and some other structures that are planned to be preserved on site. Now on the screen is an image of the county's GIS system. The property is shown in purple again, located along the intersection of South Beaver Creek Road and South Wilson Road. The site is generally 0.4 miles southeast of Oregon City and the urban growth boundary here, east of Highway 213, and less than a mile north of the hamlet of Beaver Creek, which is shown at the south end of the screen. The general vicinity is significantly affected by development of rural residences, and this application is consistent with the overall land use pattern of the area. Here on the screen is the Clackamas County's non-urban area land use plan, or the comprehensive plan. The site is located outside of the urban growth boundary and Metro's designated urban and rural reserves. You can see the site with the purple boundary again, designated R for rural. And again, the surrounding area has a like designation. Moving forward to the Clackamas County's non-urban area zoning map in accordance with the comprehensive plan. You can see the site is currently zoned RRFF5, and this application seeks to apply RA2 zoning with a 2-acre minimum. You can see here the 5 residential zoning districts allowed under the rural residential comp plan designation. And again, the site is looking to apply RA2 zoning. The Clackamas County Comprehensive Plan includes guiding goals and policies for rural land. Most relevant to this application is Rural Policy 4MM11.1, which provides the criteria for application of RA2 zoning district. Through Board Order 2000-57, the Board of County Commissioners has interpreted some findings for these definitions, including generally 2 acres means less than 2 acres, generally means a simple majority of parcels within the area, and area means a majority of the parcels within a rural land use designation that are at least partially located within a 1/4 mile of the boundaries of the property considered for a zone change. And these definitions are important as we move forward to discuss criterion A, that parcels are generally 2 acres or smaller. The application provided a parcelization study in accordance with the Board of County Commissioners' findings acknowledged by county staff. As demonstrated in the parcelization study, 78% or a simple majority of parcels within a 1/4 mile of the property boundaries are 2 acres or smaller. You can see the 1/4 mile boundary here is shown with a green overlay. Parcels that are 2 acres or smaller are shown with orange lines, and parcels 2.01 acres or larger are shown with blue lines. Based on the analysis of the 204 properties wholly or within the 1/4 mile radius, 76% of the properties are 2 acres or smaller and contain structures. As such, the area is found to be significantly affected by development. The applicant concurs with staff findings on page 26 of the staff report that the only thing that might make the 2-acre lots on the subject site dissimilar to many neighboring rural residential lots is that they would actually be significantly larger. Back to the relevant comprehensive plan criteria for the application of RA2 zoning, we just discussed that criterion A and B are met. Moving along to criterion C, the project must find that there are no natural hazards and the topography and soil conditions are well suited for the location of homes. Martha went into detail on this, but essentially the application included a wetland delineation with concurrence from DSL that showed that there was no wetlands, rivers, or streams located on the site. The property is also relatively flat and it is found to be well suited for homes. So criterion C is found to be met. Criterion D involves the availability of a public or private water system. A signed statement of feasibility from Clackamas River Water is included within the application materials. This criterion is met, but will be expanded upon later in the presentation. Next, criterion E requires the property is in proximity to an unincorporated community or city. The site is 0.4 miles southeast of Oregon city limits and a mile north of the hamlet of Beaver Creek. So that criterion is met. And lastly, criterion F does not apply in this case because the site is not adjacent to an urban growth boundary, so it has been struck from the screen. As such, the application is consistent with policy 4MM11.1 of the comp plan, and the review body may find that the RA2 zoning may be applied to this property. Before you is the Mann Brothers Estate subdivision. The preliminary layout provides 28 lots for future single-family detached homes. As illustrated, the entrance to the neighborhood is from South Wilson Road, as well as private access for lots 1 through 5. So you can see here, the lots just adjacent to South Wilson Road will have private driveway access. And again, Road A will be the main entrance to the subdivision coming from Wilson Road here. The internal transportation network is composed of private local roads to be maintained by a future homeowners association. The project also includes perimeter street improvements to South Beaver Creek Road to the west and South Wilson Road to the south of the property's frontage. There is an emergency vehicle access shown with an asterisk along South Beaver Creek Road. That access will be gated and used by emergency apparatus only. Lastly, the subdivision will also be served by rural facilities. And that extension of rural level of services will adequately serve the site. Water service is planned to be provided by CRW as demonstrated by the completed statement of feasibility. As Martha mentioned, Clackamas River Water is a regional water service provider serving properties within Clackamas, Milwaukee, Happy Valley, Portland, Oregon City, and others, as well as unincorporated areas of Clackamas County. The same degree of water infrastructure improvements, in this case water line extension, would be required for both urban and rural uses, regardless of plan or zoning designation. The site is also currently served by CRW. Adequate storm drainage facilities are intended to be provided and conveyed to the public right-of-way in accordance with the county's Department of Transportation and Development standards. An assigned statement of feasibility from the county was provided. Individual on-site subsurface wastewater disposal systems will adequately serve each future home site, and those approximate locations have been evaluated and approved by the county sanitarian. You can see on the screen there's some small rectangles, and those are the locations where a septic system would be allowed to be implemented. And lastly, franchise utilities will be extended through the site, including power, natural gas, and communications. The approval criteria for zone changes are found in ZDO section 1202.03. We previously discussed how the RA2 criteria of 4MM.11.1 are met. The application materials also demonstrated consistency with other relevant goals and policies of the comp plan, and we could dive into that further if there are more questions. The development under the proposed RA2 zoning district must be adequately served by rural facilities. We just went over how that is the case and can be provided to meet criterion B. And then criterion C and D relate to the adequacy and safety of the transportation system. A transportation impact study was prepared by Lancaster Mobley, scoped and completed in compliance with the applicable Clackamas County zone change standards and the state's transportation planning rule. Lancaster Mobley staff is available at the hearing today if there are any questions on that. And as demonstrated in the staff report on pages 20 through 39, the application is consistent with the zone change approval criteria. Moving forward, the approval criteria for subdivisions are found in ZDO section 1105.05. Criterion A states that the subdivision must comply with the underlying zoning district. In that case, that would be the RA2 district, and the application demonstrated consistency with those lot dimension standards, density, setbacks, and so forth. The property is not within an urban low density residential district, so criterion B is not relevant and has been struck from the screen. Criterion C involves a phasing plan for a subdivision. In this case, that's also not applicable because the subdivision is planned to be implemented in a single phase, so criterion C has been struck. Criterion D involves a homeowners association be implemented if necessary, and in this case, the homeowners association will take over maintenance of the private roads internal to the site. And lastly, criterion E involves a future urban area. Again, we've discussed in detail how this site is rural, and so criterion E is also not applicable. So as demonstrated in the staff report, pages 57 through 58, the application is consistent with the subdivision approval criteria. And at this time, I'd like to give the floor over to Andrew Stamp to continue discussing some criteria.
And Ms. Holliday, will you be submitting your presentation as an exhibit?
Yes, sir.
Thank you.
Good morning, Mr. Hearings Officer. Again, for the record, my name is Andrew Stamp. So we agree with most of what staff said. There are a couple points that I would like to disagree with, but we don't disagree with staff's overall conclusion, of course. But there is some of the roadmap on how to get there. We take a few turns differently. One of them is that I fundamentally don't think the goals apply to this zone change at all. As Marie noted in her slides, Clackamas County has a comprehensive plan and a zoning code. They're two different documents. Each of those documents has its own map. We have a comp plan map and we have a zoning map, and they're two different maps. We are not seeking to amend the comp plan map. That map shows us as rural before. We're going to remain rural afterwards. And it's that map that if you're changing it, that you have to apply the goals. We want to change the zoning map, and the zoning map changes don't necessarily trigger the application of the goals. And that's probably the most fundamental point that I can get across today. The comprehensive plan map, as Marie noted, has 5 zones within it in the rural area, 3 of which are relevant here: FF10, RRFF5, and RA2. The only really, I mean, there's slight differences between them in the uses allowed, but the big thing is there's a lot size difference. That's probably the most fundamental characteristic difference in them. So the other important thing is to realize is that your comp plan, and I think you understand this because you've dealt with this before in the Terragano case, or however that's pronounced. The comprehensive plan has criteria that tell you when something should be RA2, or when it should be RFF5, or when it should be FF10. So differentiating between those is something that you have in your criteria in your comp plan. That is an extremely critical factor. Next slide, please. Because ORS 197-175-2 tells you when and when not to apply the goals. So what it says under sub A is that the county shall prepare, adopt, and amend and revised comprehensive plans. Note it doesn't say zoning codes, but comprehensive plans in compliance with the goals approved by LCDC. Then slips going down to sub D. If the comprehensive plan and land use regulations have been acknowledged, which in this case they have, you make land use decisions and limited land use decisions in compliance with the acknowledged plan and land use regulations. All right, that's the differentiating thing. It doesn't say, under sub D, it doesn't say you make them in compliance with the goals. It says you make those decisions in compliance with the plan. Next slide, please. So LUBA's standard of review is really important in considering how 197-175 sub 2 works, because it's kind of the bookend of, these two statutes are bookends of one another. Under subsection 5, the board can reverse a land use decision if it's not acknowledged, if it doesn't comply with goals, okay, straight up. Under sub 6, the board shall reverse a remand and amendment to a comprehensive plan if it's not in compliance with the goals. Okay, that's good. That's consistent. Number 7, if you amend a land use regulation, which includes or if you adopt a new one, then you look to see if it's in compliance with the plan. Or if the comprehensive plan does not contain specific policies or other provisions which will provide the basis for the regulation, or in this case, the map amendment, and the regulation is not in compliance with the goals, then that's how you apply the goals to anything else. So you look to see whether the comp plan has specific policies or provisions which provide the basis for the change. And that's why, next slide. We didn't go back and change. Well, go back to go back one. One more. Where was the one?
This is the one you were talking about.
Yeah. So in this, what we have there is we have the specific policies in the comprehensive plan that tell you when you go to FF10, RRFF5, and RA2. And they're somewhere in this PowerPoint presentation, we lay those slides out. So let's just keep going. All right. So that's the basic format. Now I want to turn to goal 11. Give a little background on goal 11. It was first enacted, like all the other goals were, in 1975, 2 years after Senate Bill 100. When this goal first came out, it was written in a very broad brushstrokes. The goal said you were supposed to plan, the county was supposed to plan a timely, orderly, efficient arrangement of public facilities. They provided a definition of what that meant. And they talked about urban and rural development shall be guided and supported by the types and levels of facilities that were appropriate for the needs of those areas. And then they had a definition of rural facilities and services that said refers to facilities and services which the governing body determines to be suitable and appropriate solely for the needs of rural use. So the idea there was you weren't going to put urban services out on rural lands, but it was all worded kind of vaguely. So next slide. It took about 20 years for everyone to figure out that we probably needed some more detailed guidance on what that meant. And so in 1994, LCDC enacted a change that was relevant here. It wasn't the first time they changed Goal 11, but it's the first time it was really relevant to the rural uses. And what it said, for the first time, they dealt with water systems specifically on rural lands. And it says, for lands that outside of UGB, county land use regulations shall not rely on the establishment or extension of a water system to authorize higher density, residential density that would be authorized without a system. So what they were saying was, you can't zone land with lower or smaller lot sizes just because you have a water system out there. They also changed the definition of rural facilities and services and took out the discretion that the previous definition had. Now it just says refers to facilities and services suitable and appropriately solely for the needs of rural land. Before it said which the county determined to be suitable, which the county said gave them sort of discretion, and so DLCD took that away, or LCDC took that away. Next slide, please. Now, of course, anytime you change the rules, it's going to lead to litigation, and the 1994 amendments to Goal 11 and were no different. The key case here is DLCD versus Lincoln County. What happened there was a developer named Pacific HW Investments proposed to do 113 unit PUD on 50 acres, so roughly half-acre lots outside of the urban growth boundary. I think we all agree that that's an urban use of rural land now, with the benefit of the Curry County decision in 1986. But what was key to this was the site was within a service area of a water district. An existing water district covered the entire area. Now, what's really critical about this case is the Lincoln County zoning code had different lot sizes depending on whether or not the water or sewer were there. And I summarized them in a little chart over on the right there. If you had both water and sewer systems available, you could get 6,000 square foot lots, which is, just urban density residential. If you had either water or sewer, but not both, then you could do 15,000 foot, because presumably you'd need some more space there. And then if you didn't have either water or community water sewer service available, then you had to stick with 2-acre lots. Now, DLCD didn't like that, so they filed the litigation and they ended up losing. Court of Appeals said that's not a Goal 11 a violation because it doesn't involve the establishment or extension of a water system. They said the water system's already there, so you're not establishing it or you're not extending it. Well, DLCD said, hey, we don't like that result, so we're going to change the rule, which they have the ability to do. LCDC does anyway. And so within 2 years of that decision coming out, we had a new rule amendment. And this time DLCD really doubled down on making sure that what happened in Lincoln County couldn't happen again. And that's the reason that the Lincoln County's case is so important. It provides context for this 1998 amendment, which is the current version of the rule. So in 1998, Goal 11 was amended. Now it says local government shall not rely on the presence, establishment, or extension of a water system to allow residential development of land outside of UGB at a density higher than authorized without service. Okay, so they added the word presence. But to make it abundantly clear, they also added a definition of extension of a water system, and that says means an extension of a pipe conduit, et cetera, from an existing sewer water system in order to provide service to a use that was not served by the system on the applicable day of the rule. So that really just made it absolutely clear that the result in the Lincoln County case would not happen again. Next slide. Okay, and then at the same time, they also made an administrative rule. In addition to changing the goal itself, they did an administrative rule, and that's where staff earlier in their presentation mentioned these 3 situations here. And what it says, consistent with Goal 11, local land use regulations that are outside of UGB shall not allow an increase in base density of a residential zone due to availability of water. They won't allow a higher density of residential development, or they won't allow an increase in the allowable density. Whatever the nuances are of the three different formulations, I haven't seen a good explanation of what the difference is between those three. I don't think it's really critical in this case to understand the nuance between those three. I think it's safe to say that subsection 3, the one I've underlined, is probably the one that would apply here. So then we go back to the Clackamas County Comprehensive Plan. And keep in mind, it says, this is your criteria that tells you whether you're R2, RA2, RRFF5, or FF10. And what it says is that if you want to zone something RA2, you have to meet all of these criteria. One of the criteria, sub D there that I've highlighted, says a public or private community water system is available. If you don't have one available, then you're automatically not going to be RA2. You're going to be RFF5. And so what that does, in my estimation, means that you're doing exactly what DLCD didn't want you to do, and that is allow different densities of land depending on whether water systems are available. Next slide. The administrative rule tells you what the solution is if you run into that problem. And what I said here, that that code comprehensive plan provision allows RE2 zoning if a community system is available. And that's exactly what in my opinion, what subsection 2 of the OAR prohibits. But subsection 3 of the OAR says the solution here is just don't apply that provision. It says under sub 3, applicable provisions of this rule, rather than conflicting provisions of a local acknowledged zoning ordinance, shall immediately apply to land use decisions filed after this date of the rule. So my conclusion is the solution is just apply the remaining RA2 criteria and not that one. And I've shown you here visually how that looks. You just scratch it out, don't apply it. But you've got 4 other criteria that still apply. Those are acknowledged. You can apply those criteria. And that's a slightly different formulation than what staff said. We get to the same result as staff, but this could definitely be an alternate set of findings that I think would be survivable. I think if I were the hearings officer, I'd write both set of findings. So anyway, next, we'll move on to goal 14. As I said, I've got all the goal 14 cases, I got a binder here. Statewide planning goal 14, urban uses on rural lands. That's all the cases that I've ever found. I've never found one where they applied goal 14 to a zone change, particularly whether you weren't going under 2 acres. When goal 14 applies, it applies when you're amending your comp plan. And most of these zone changes, it's a post-acknowledgement plan amendment and a zone change. We're in a little bit of a unique situation here because we're not seeking to go, for example, from EFU to rural. And since the Clackamas County Comprehensive Plan does contain those specific criteria and it's acknowledged, those regulations are acknowledged that you don't need to apply statewide planning goal 14. Next slide, please. The goal 14 administrative rule is a little bit different animal. It says it does apply to rural residential areas. It does have an exception. It has a bunch of exceptions really, but the first one is at subsection 44B, which basically says that if it was a grandfathering clause, it basically said if we already acknowledged, we as in DLCD and LCDC already acknowledged your comprehensive plan during periodic review acknowledgement or during a PAPA proceeding that occurred after the Curry County case came out in 1986 and before this rule, then we're going to grandfather you in on whatever we approved before. That is the situation that Clackamas County is in, as Ms. Fritzie noted. But then it says, nothing in this rule shall be construed to require local government to amend its acknowledged comprehensive plan or land use regulations for those rural residential areas already acknowledged to comply with goal 14 in such a proceeding. And then it says, however, if the local government later amends its plan provisions or land use regulations that apply to rural residential areas, it shall do so in accordance with this rule. And what we say here is Clackamas County falls under that initial periodic review. So whatever it's done in the past is still good. Next slide, please. The next interesting rule is subsection 6, which Ms. Fritzie mentioned. Rural residential zone in effect shall be deemed to comply with goal 14 if it's 2 acres. All right, good to go. We've got an RA2 zone. In your comp plan, we have provisions on how to designate that RA2 zone. Those criteria are all acknowledged. And the next one here, it says any rural residential zone will not comply with goal 14 if it allows creation of new lots smaller than 2 acres. So you have an RA1 zone. That's a little bit dicey to the extent it's outside of an unincorporated community. I'm not sure. I think maybe that code's already been cleaned up to get rid of those. But in any event, that shows you an example how any sort of RA1 zone would already be subject to goal 14. Next slide, please. Subsection 7, another interesting provision. After October 4th, 2000, a local government requirements for minimum lot or parcel size in rural residential shall not be amended to allow a smaller minimum for any individual lot or parcel without taking an exception to goal 14. This case is the one that Ms. Fritzie mentioned, Oregon Shores versus Curry County, 53 or LUBA 503. LUBA said that applies to text amendments, not map amendments. Next slide. Oh, actually, sticking with that slide for just a minute. LUBA said, if a county amends its RR zone to now allow a 2-acre minimum lot size as a third option, which in that case, they had a 5-acre zone and they had a 10-acre zone, but they said, if you have this new RA2 zone that didn't previously exist, that must be justified by a goal 14 exception. So for example, if Clackamas County were to come up with an RA3 zone or an RA6 zone, those would be subject to the goals under this decision, because that's a text amendment. And then it says, LUBA said, the section 7 does not, and back then it was called 6. So if you read the LUBA case, the numbering's off compared to the new rule, the current codification of the rule. But it says, LUBA says that subsection 7 does not require Curry County to require that any property currently zoned RR10 that seeks to rezone to RR5 must also take an exception to goal 14. And they said, well, that would be a collateral attack on the acknowledged code, because their code specifically told you how to go from RR10 to RR5. And so LUBA said, if you are doing a map amendment to go to rezone land from 10 to 5, you don't need to comply with goal 14. That's exactly the situation we have here, because we have 2 existing zones, an R5 zone and an RA2 zone. We have criteria that tells you how to go from one to the other, and those criteria are acknowledged, so there's no opportunity for the goal or to apply. All right, subsection 8A, this is the last of the poorly written LCDC rules that needs to be considered. And what it says, for rural residential areas designated after the effective date of this rule, the affected county, and keep in mind that's new residential areas. So if you had a EFU area that you're trying to turn into a rural residential area and amending the comp plan, that would trigger this section. And what it says, it requires 2 things. One, require that each new lot or parcel have at least a 10-acre zone. So that would apply if you had some land out that's zoned EFU, but you determine it's not agricultural, it doesn't meet the definition of agricultural land, and therefore should never been zoned EFU in the first place, and you want to rezone it to rural residential. This rule says that post-acknowledgement plan amendment and zone change would require you to have a 10-acre lot size. Or, as an alternative, if you establish a minimum lot size of at least 2 acres for new lots or parcels in accordance with their requirements do that with an exception. Oregon Shores said there that applies if you're designating a new rural residential area on a comp plan, which we're not. We're already an existing rural area. And two, you're authorizing RA5 or RA2 zoning to be applied to a newly designated rural residential area, which again, we're not. So I'm trying to go through that quickly, but that's why 8I does not apply. Next slide, please. All right, that's all I want to discuss on that. We do have pretty extensive briefing on that. I noticed when I went through my Goal 14 memo a couple days ago, I noticed that I had an error in there that probably is confusing. And what I'm going to do is I'm going to resubmit that letter with the corrections made in it. And I'm going to ask that you, to the extent you read that, disregard the old version and read the new version, because I was a little bit mad at myself that I gave an incorrect cross-reference. It's going to be maddeningly confusing. So I apologize for that. So in conclusion, the applicant agrees with staff's findings and recommendations to approve the zone change and subdivision application, with the exception of some of the conditions that we talked about. We accept all those conditions except for that one condition for Gulf 5. We'll talk about that in the open record period. And then finally, I'd like to say we appreciate, this is a complicated case. We appreciate the hearings officer's time in considering this application, and would appreciate the hearings officer's approval based on the findings in the application and the staff report that we've discussed. Thank you very much. If there's any questions, we're certainly here to entertain them. We would like to reserve some time for rebuttal when we hear opposing testimony.
Thank you, sir. And you'll submit two things then, your presentation as an exhibit and also an updated memo. I did have an opportunity to review your memo, but I'll disregard that and I'll mark up a new one.
I appreciate it. I'm sorry for that typo. It was kind of annoying to find it, but it is what it is.
It is. Did the county have anything they wanted to add to this at this time, or show? At this time, I'm considering moving to a public forum. No?
I do not have anything to add at this point in time.
Mr. Blessing. Okay. At this time, I'd like to invite members of the public to participate in this hearing. Use the raise hand feature and wait to be called on.
I have two hands raised. First, I have Aquila Hurd-Ravich, followed by Elizabeth Grazer-Lindsay.
Okay, the first one, please. And when you're invited, please state your name and address for the record.
Good morning. My name is Aquila Hurd-Ravich. I'm the Community Development Director for City of Oregon City. My address is 695 Warner Parrott Road, Oregon City 97045. I just wanted to make a brief statement. We submitted comments about the transportation impact analysis. So I just wanted to kind of point that out, that those comments are in the record. I did see the staff's response that they feel that it complies with their county roadway standards for intersections that need to be studied. This is a matter that the city will continue to work on with the county. We'll probably continue to make similar comments for other zone changes. We're concerned with the congestion levels at two intersections, Highway 213 and Beaver Creek Road, and Highway 213 and Redland Road. Those roads are not city jurisdiction, but the city manages the congestion. And so we'd like to continue working in ways that we can with the county to address those. So we saw this as an opportunity to start raising this as a concern. And I will leave it at that. Thank you.
Thank you. And I think that you're directing attention to the issue that is being raised by a significant number of community members that use those transportation facilities. Who was next?
I have Elizabeth Grazer Lindsay, followed by Kelly Reed.
Miss, the first one, please.
Hi, this is Elizabeth Gracer Lindsay. I wanted to first address that the application does not comply with the county safety standards and criteria for a zone change. The law 120203 says a zone change shall be subject to the following standards and criteria. D, safety of the transportation system is adequate to serve the level of development anticipated by the proposed zone change. And I want to stop for a second and mention that there was a corrected document sent to you. So make sure you get the one that says corrected in the title and not the one before that, because a couple of the appendices were switched.
I did receive an exhibit 65 perhaps this morning, and I skimmed it pretty quickly, but I'll look for an updated version of that. Is what
Thank you.
Okay.
Okay, so the transportation system is currently not safe, and so it doesn't meet the adequate level that the law calls for a rezone to happen. And so there's a lot of ways that we can see that it's not adequate right now. So it can't handle more load. I am showing an ODOT accident report. It's overlaps with the one the applicant shows. It's 2 years different. The applicant only looks at just slightly more than the frontage of the property. The traffic report that I show shows from the urban growth boundary, which they say is a 4/10 of a mile from the lot to the unincorporated rural center, which I believe they said was a mile further, and then it wraps around to the elementary school. This traffic report in this immediate traffic impact zone shows numerous accidents at intersections and also in between intersections. The accident-prone stretch, it connects the proposed development site to the post office, gas station, and the elementary school and other essential services. So it's highly relevant to what the lot will be doing. Along this stretch.
I also read the material you submitted about the use of the road, I think for bicyclists and horses as well, horse riders.
Is that Carl? Okay.
I think we've lost.
Yes, so I'll go forward to that section. So this stretch of the roadway does not have proper sight distances. It has many vertical curves called hills and horizontal hills. And that results from when this road was first paved, it was originally used for horse-drawn wagons, and it was never graded to bring it up to proper sight distances for modern speeds. So that's why in the staff report, they say that there's been a lot of rear-ender accidents at Beaver Creek Road and Wilson Road. And this type of accident is happening all along Beaver Creek Road at intersections and even between them because of inadequate grading for proper sight distance. The inadequate sight distance was actually measured at Beaver Creek Road and Ivell Road by County Traffic Engineer Rick Nye. And a fatality occurred at this intersection. It's less than a mile from the site. When a multi-car rear-ender situation happened, and one of the drivers who survived mentioned that it was a blind hill situation. That's documented in my materials. This application is not safe in terms of sight distance unless the Beaver Creek Road is created to create proper sight distances, either by approval criteria or some other means. But without that being corrected, this is not safe and doesn't comply with approval criteria. Throughout this heavily used transportation impact zone of this application, Beaver Creek Road is not up to the county roadway standards. For example, C-140 that's mentioned in the staff report. There's a section of the roadway that you can look at, and it shows that there's no bike facility, which is 8 feet of pavement on both sides of the road. There's no gravel shoulder, and there's no recovery zone with limited slopes, as the county roadway standards require. The application on page 205, exhibit 2 of the 511 pages, has a transportation report, which wrongly shows bike lanes on both sides of Beaver Creek Road. So the traffic analysis is wrong in saying that. And my picture on page 4 shows the road at the property, and it shows that there's no bicycle facility, no gravel, no recovery zone. And it actually just drops off and leaves the bicycle and pedestrian with nowhere to be, except for in the lane of traffic with high-speed vehicles.
Excuse me, one minute. We have lost our hearings officer, and I know that he can certainly listen to the recording of this testimony, but
yes, I'd prefer to wait for him to come back. I'm sorry.
That's quite all right. But do we know what's going on, Darcy? Hang tight, just 1 minute.
Okay, yes, I invited him back in. I don't know what happened. He said he has a technical issue he's working to resolve. So just hold tight for a second.
And just to be clear, he will have access to the recording of this, and I'm sure we'll listen to whatever he missed in your testimony.
Okay, I have him as an attendee. I'm moving him over.
I apologize. I have no idea, but I had some technical issue which kicked me off the meeting. Ms. Elizabeth
Lindsay.
Lindsay, you were speaking about traffic impacts and accidents, and that beyond the frontage area of the property. And I also wanted to say that I did read, as I said, pretty quickly, but read your written comments, and you also referenced bicycles, particularly your accidents, and just and also with involving, I think, horse riders as well.
Yes, I did want to go on to the next section. I didn't see the exact moment you left, so I hope I don't repeat anything. So I wanted to mention that that large stretches of this impacted zone don't have proper sight distance. This happened because Beaver Creek Road was originally a horse-drawn wagon road, and it was paved without grading for modern speeds. So it has the blind hills and turns. And this explains why the staff report notices there's a lot of rear end accidents at Beaver Creek Road and Wilson Road at the corner of the site. And they required that there be a condition that there be a turn lane. But what isn't commented on there is that this type of rear ender is happening up and down Beaver Creek Road due to the inadequate grading for proper sight distance. So this needs to be corrected in order for there to be safety. That road needs to be regraded. And an example of an inadequate sight distance problem was that County Traffic Engineer Rick Nye measured the sight distance at Beaver Creek Road and Ivell Road and determined it to be inadequate. And at this same intersection, which is probably about a half a mile south of the corner of the site, a fatality occurred in a rear-ended situation where one of the survivors described it being a blind hill. That's in that's written up in this documentation I give you. So then to go to the next topic, the Beaver Creek Road in this impact zone of the application is not up to the county roadway standards. And the county staff specifically mentioned C-140, which I put that figure into the document for you to see. So the proper roadway that's up to county standards has a bike facility, which is 8 feet of pavement on both sides of the road. It has a gravel shoulder on both sides of the road and a recovery zone with limited slope. And those things are all missing from Beaver Creek Road. And you can see that on the picture that I provided on page 4, which is, it shows what the road looks like at the edge of the applicant site. The applicant has a transportation report on page 205 of their exhibit 2 out of their 511 pages, and it wrongly shows bicycle lanes on both sides of Beaver Creek Road. But the picture that
I missed it. What page were you referencing?
205 of the application, exhibit 2.
Mm-hmm.
And it wrongly shows bike lanes on both sides of Beaver Creek Road. But as you can see in that picture, they don't exist. And that legal requirement doesn't exist anywhere in this stretch. This lack of the road being at roadway standards, the county's roadway standards being achieved, puts bicyclists and pedestrians at risk, and they don't have proper safety. So to go to those points, they have to share the lane with high-speed, high-volume motor vehicle traffic in this area near the urban growth boundary. And we have a report of a serious bike accident. Also, the Beaver Creek Bulletin report on it and other reporting on it is in this documentation.
I see it as well.
Yes, and the person ended up with a brain injury. The last time the county measured the bike traffic in this section, there were over 50 bikes on one day of the study. And the Hamlet did a survey of residents, and they found that most were afraid to use the road for biking. What we find is the people who are using it, there's a few of the serious recreationalists, usually not on Beaver Creek Road, but adjacent roads. But these are people who are commuting to work. The Oregon's transportation planning rule provides for all modes, including biking and walking. And we see that this Beaver Creek Road facility at and adjacent to this property does not provide safe transportation for bicyclists and pedestrians, does not provide a transportation system to serve those who don't drive, doesn't provide pedestrian and bike access, doesn't reduce generation of greenhouse gas pollution by providing for active transportation, hasn't recognized or remedied past displacement of pedestrians, bicyclists, and equestrians, hasn't engaged underserved populations, hasn't been protecting the function for bicyclists and pedestrians. Those are all things required by the transportation planning rule. And I noticed in the applicants, the application on 4 different pages, 239, 241, 243, 245, that they show very low bicycle numbers, much lower than what the county measured in its most recent record. And I don't know if it's because they were measuring only at peak hours and that bicyclists tend to avoid peak hours because it's more dangerous, or if actually the traffic levels have gone up and bicycling might have gone down because people are more afraid of dying. In terms of the equestrians, I wanted to point out that the county's comprehensive plan on the transportation plan on page 5-2 talks about balancing all needs, and it includes in some localities equestrians. Without the impacted roadway being brought up to the county roadway standards, the zone change criteria of safety cannot be achieved for pedestrians and bicyclists, and the application cannot be approved. Because of the danger of this stretch of Beaver Creek Road, the county hired a consultant to conduct a Beaver Creek Road safety audit in 2012. And none of the infrastructure needs that were listed there have been addressed. The application cannot be approved as safe and in complying with the zone change criteria without the items listed in the roadway safety audit being remedied. There's extensive testimony from people in Beaver Creek that
I do want to read all of the comments that you made, and I understand you're going to submit a revised memorandum or written testimony for me to consider in this, but I also want to provide opportunity for other people to submit public testimony here today for consideration. Will you please make sure that you include all of your comments that you want considered in your updated written testimony and submit that to the county as indicated?
I will. May I give you just
and
one
thank you for your
additional
public-
sentence?
Yes.
One additional sentence.
Of course.
Because I'd like to highlight something that also contrasts with the staff report. And that is they said that there aren't any flood hazards, and the state wetlands inventory shows temporarily flooded as a category of part of the site.
Okay.
And that's on page 9 of the materials that I sent you.
And I'll look specifically for that page 9.
Thank you.
Okay, thank you. And I believe we have Ms. Kelly Reed.
I do. I have Kelly Reed, followed by Tammy Stevens, followed by Norman Andreen.
All right, let's have Ms. Reed.
Hi, can you hear me?
Yes.
Hi, good morning. Nice to see you all. My name is Kelly Reed. I work for the Department of Land Conservation and Development, DLCD, as the regional representative for Clackamas County. Mailing address is 635 Capitol Street Northeast, number 150, Salem, Oregon, 97301. DLCD submitted written testimony in the record, similar to the letters that we submitted for the last 3 rural residential zone change proposals approved in Clackamas County. The basis of our comments has been that a Goal 14 exception is required for zone changes or upzoning in rural residential zones based on Oregon Administrative Rule 660-004-0040 sub 7, as discussed already by county staff today. The current proposal does not include a Goal 14 exception. DLCD appealed The last proposal that came before the county, the Sarajevo proposal, that case is currently pending at LUBA. We request, as Martha mentioned, we request that the county delay its decision on this proposal until the LUBA appeal has been resolved. It's our expectation that the LUBA decision will settle the question of whether Goal 14 exception is required for zone changes such as this one. Furthermore, we want to clarify that residential development outside of urban growth boundaries is not, as a matter of law, needed housing. While there may be an interest in rural residential development, this type of development in rural unincorporated areas without full urban services is not and has never been considered needed housing. The state's efforts in housing production are focused on urban areas where services are nearby and transportation options exist. To move on briefly to Goal 14, we disagree with the applicant's argument that the Goal 14 doesn't apply here. The county comprehensive plan is silent on when a Goal 14 exception is required. And even though the comprehensive plan does have policies on where and when to apply its various rural residential zones, it doesn't mean that Oregon Administrative Rule 660-004-0040 sub 7 does not apply in addition to the county's comprehensive plan policies. In other words, counties have a responsibility to apply their acknowledged program, but doing so does not relieve them from the duty of also applying applicable state law. Any land use application that doesn't comport with statewide planning goal requires a goal exception. In 2000, the Land Conservation Development Commission adopted the rules in Division 4 to put some sideboards on rural residential exception lands in order to be consistent with Goal 14, which very generally is meant to keep urban uses out of rural areas. One important piece of these rules that we've been discussing says that any change that would allow a smaller parcel size than what was allowed at the time of rule adoption, which was October 4th, 2000, requires an exception be taken to Goal 14. This proposal, which would take a large parcel that is zoned for 5-acre lots and change it to a new zone that allows 2-acre lots, very clearly falls into this category, we think, and therefore requires the exception. DLCD also contends that a Goal 11 exception is required, and we stand by the reasons stated in our written testimony. And last, the applicant argues that the 2-acre lots are rural uses, but statute and case law tell us that 2-acre lots are not inherently rural. The fact that a public water system will be provided, that street widening and storm drainage infrastructure, transportation improvements are required to serve this development, that property is so close to the existing UGB, all those factors make it more difficult to really make the case that this is a rural use. We hope that you refer to our letter in the record for elaboration on all these points. And again, we request a delay in the decision until the other LUBA appeal is resolved. Thank you very much for your time today.
Thank you. And the delay issue is tricky here. I noted that request in the exhibit. I have your letter as exhibit 15. The 150-day deadline for final action on this for the county is April 15th. So there is a little bit of time here. But even if it is delayed, I'm not sure that how the LUBA issuing its decision will really impact this decision, because there's no I don't see how I could determine that would be the end of the matter. If for example, DLCD does not win its appeal on that, it would seem to me that it's likely that DLCD would simply appeal that decision, and it wouldn't provide certainty either until we have an answer from the Court of Appeals. What's your response to that concern?
We understand the 150-day deadline, and understand the county is obligated to meet that. And I think to the extent that the LUBA schedule might allow for, any sort of decision, we would appreciate being able to know that answer before this decision is made as well. But I understand your point, and that may very well be true, that it won't really give us any clear resolution.
I certainly would appreciate the clarity as well. But I think that, as I suggested, that it may be that that clarity will come from an appeal of a LUBA decision, and that's not going to happen for a while, if it happens.
Understood. Understood. Thanks.
I'll consider it and look it over again, but and as I indicated earlier, in a brief discussion, it looks to me that the record will be extended a minimum of 3 weeks, and so that will provide some additional time.
Thank you.
Okay, thank you. Another public participant?
Good morning. Can you hear me?
Yes.
Wonderful. My name is Tammy Stevens, and I chair the board of the Hamlet and Community Planning Organization of Beaver Creek. Our address is P.O. Box 51, Beaver Creek, 97004. First, thank you very, very much. We always appreciate this opportunity to provide input to you, Mr. Cox, and staff and applicant. Thank you so, so much. As you saw, and Ms. Fritzy noted, our letter of February 1st, and that letter was 4 pages of comments and inputs from our community after a community meeting on January 24th. So I'm not going to go into all that because I'm pretty confident you've read it and there's not a lot new there. I appreciate Elizabeth Grace or Lindsay's testimony. There were several things there I was going to bring up, as well as Kelly Reed. So I'll get cut to the meat on a couple different things. One is that I too read the very extensive traffic report in the application, which is certainly necessary and valuable. However, the word I'm super stuck on, both in the traffic report as well as the county's report, is the word adequate. Last Tuesday, had an appointment in Oregon City. I live way out in the rural parts of Beaver Creek. 7:45 in the morning, the traffic was stopped, or no more than 3 miles an hour from the high school on Beaver Creek Road to 213, over a mile. We crept in. There was no accident. There was nothing more than the 2 intersections that Aquila with Oregon City cited. Oregon City or Beaver Creek in 213, as well as Redland in 213. And until those are resolved, Beaver Creek Road could be 8 lanes wide. That's not going to solve anything. We have bottlenecks, and those bottlenecks are on nobody's plan and nobody's funding. So until those are fixed, I'm not saying that this subdivision is adding to the problem, because they're not. They don't exist, doesn't exist. But will they add? Yep, over 200 trips a day is going to substantially add to that problem. So after my appointment in Oregon City at 8:15, I'm driving home on Highway 213, and the traffic is stopped, or no more than a couple miles an hour, from 213 south to Leland Road. It's like 1.5 miles. I mean, I don't know how anyone in their right mind could utilize the word adequate traffic when you see this on a non-event day. So I kind of want to throw that out and kind of do a real bones example. The other thing that I struggle with is I've lived in rural Beaver Creek for 62 years, and there is such a huge difference between farm forest 10-acre, where you've got timber and trees and orchards and big livestock. And then you've got rural residential farm forest, 5-acre. So you've got blueberries and goats and sheep, and you've got lots of activity to help feed the community and promote agriculture. Then you get RA2. Well, what are those? Those are McMansions with a basketball court and a swimming pool. That is not rural. That is glorified urbanization. And I'm speaking just for and representing the citizens of Beaver Creek. You're going to see that in the many, many emails that you've received. This is rural urbanization, however you want to define it. It is not farming and it's not forestry. So it is a big difference when you go 2 to 5 acres. And other than that, as always, staff has just done such an amazing job on their report. I don't know that I'm going to add anything else in addition to our letter. I'm super proud of our community's interest and participation, so I thank them all. And that's really all I had, unless you had a question, Mr. Cox?
I did read your submission, and I appreciate your participation in this hearing. It is very important, and it is community involvement and action that does get road improvements and does get some infrastructure and makes changes in what is allowed in these rural versus urban.
Thank you, Mr. Cox, very much.
Thank you.
Uh-oh, we lost him again.
Oh, am I frozen again?
You're frozen, but we can hear you.
Are you still there, Mr. Cox? Oh dear.
Yeah, looks like he's gone again.
I wonder if he could call in.
Yeah, just call in on that cell phone number or that phone number.
I'm watching for him to rejoin.
Nothing yet.
Was in person, you just get in front of the mic. If the mic wasn't working, you just yell, right?
Yeah.
I found a bunch of dog bones, one for recipes.
Hello.
Hello.
This
Hi,
is
Mr. Cox.
I have a Comcast truck outside, and apparently they're doing some work on my provider. Hopefully they've finished. I apologize for the issue. This actually, if it continues, I'll find a new provider or a second provider availability, because that's unacceptable. And I'm embarrassed. I apologize for my disappearing. I had final comments, I believe, from Ms. Tammy Stevens. And thank you, Ms. Stevens, for your involvement and participation in this hearing. And I'll look and I will review again your the submission that you made. Do we have another public participant?
We do. I have Norman Andreen.
Hello, can you hear me?
Yes.
Great. Great to see you, Darcy and Martha. I haven't seen you guys in a long time. Just some information. My address is 15331 South Tioga Road, Oregon City, even though it's not in the Oregon City proper. Just to give you some insight into this property. My wife and I have lived on the address that I gave you for 30 years, which is South Tioga Road dead ends into Beaver Creek Road, which is directly across from this property. Elizabeth Gracer Lindsay was actually very correct in the fact that this is a very dangerous portion of Beaver Creek Road. There are plenty of dangerous portions on Beaver Creek Road. The problem with this site and our site also entering onto Beaver Creek Road is there is a slight hill, and it's a large enough hill on Beaver Creek Road going south past Wilson Road that it's very, very difficult to see an approaching car until it's right up on top of that near the intersection of Wilson and Beaver Creek Road. South Tioga Road is probably less than 500 feet from that intersection. So we deal with this all the time. Anyone that would ride a horse on Beaver Creek Road at this point would be crazy. They'd be putting the horse's life in danger and anybody that's driving by the horse. Bicyclists do not use this portion of the road very often because of how dangerous it is. There are no shoulders to speak of. I would assume that if this property is allowed to develop, that they will have to improve the site to the county standards, such as has happened at other developments just south of this area that's been developed within the last 10 years or so. There is another issue that really hasn't been talked to except for a little bit, and that's in regards to the drainage from the property. There is a small culvert underneath Beaver Creek Road that when it rains hard and for lengths of period of time, there's a portion of that property, the subject property that you're talking about, that uses that drainage culvert. That drainage culvert then goes on to a piece of property that is on South Tioga Road. It then crosses South Tioga Road with another small culvert underneath South Tioga Road and drains into somebody's pasture. I don't know if it goes all the way over into Lambert. I'm not sure about that or not, or if it just saturates the properties in that area. That property that you're looking at right now would have to have water detention sites on it. Otherwise, it will end up flooding South Tioga Road and the properties that abut that little drainage area. I personally don't mind a 2-acre parcel being put on that property. I would much rather have that going in there, then in the future, developments like we're seeing at 213 and Beaver Creek Road across from Berry Hill Shopping Center. Tammy's 100% correct in that her observations of the traffic on Beaver Creek Road continues to get heavier and heavier and heavier. Even though there aren't any huge developments that are being developed in our area, we're being impacted from other areas south of us. And with the development that's going on at near the high school that's been built a couple of years ago, the property that's being built across from Berry Hill Shopping Center, that 213 intersection is it's already in a failing position. It's going to fail even more, which will then end up affecting traffic going to the college. It will also affect traffic going to the high school and the new savings and loan office that's been developed near the high school and the college, which has, I think, 200 to 300 people that work there. The intersection of 213, Beaver Creek and Henry C. Road could possibly be affected at periods of time in heavy traffic. And to enter that property, the subject property that you're looking at, there definitely needs to be a turn lane. And if you were going to put one on Beaver Creek Road, it needs to be closer up towards the intersection of Henry C. Road and Beaver Creek, because that's the only place that you would have decent sight lines off of Beaver Creek Road. The sight line, as I said, the sight line at Wilson and Beaver Creek Road to service this property is somewhat problematic unless something is done in terms of that grade that Elizabeth was talking about. I was on the Planning Commission for Clackamas County for 17 years. So I'm fairly familiar with the problems with this, particularly in this area in regards to the county rules. And unless the city and county and state come up with some way to really drastically improve the intersections of Beaver Creek and 213, Beaver Creek and by the high school, with that development that's going in there, it's going to make Beaver Creek Road almost unusable. So that's my comments.
Thank you, sir, and I appreciate your participation in this hearing. Do we have another member of the public with their hand up?
I don't see any.
Okay. I'd like to start with the county asking if the county has any rebuttal that they would like to make or answers to any of the kind of questions or commentary made by the public, followed by a similar opportunity by the applicant. And neither of you need to do this at this time. You could submit those rebuttal comments in writing. Ms. Fritzy.
If I may start, I just have a couple of very quick comments. And I also appreciate all of the testimony that was submitted from everybody, and certainly the members of the public and the Hamlet. I think that a couple of things need to be kept in mind. And again, I'm speaking to the zone change piece of this because that's what I analyze, is that there are certain criteria that have to be met for the zone change. And specifically, I am not a transportation engineer, but there are specific parameters around what it means for the system to be adequate and to meet the transportation planning rule. And that's what the traffic study assessed. That doesn't mean that there aren't some larger system-wide issues, and we are aware of that, and we appreciate the city's comments. And also the comments from Elizabeth Grazer Lindsay. I think that As far as the specific criteria for the zone change, with the mitigation that was proposed, this proposal, staff finds, does meet the specific criteria. I think that a lot of the testimony was provided dealt with the safety of the system, and I think there are concerns about the safety of the system. That's why some of this mitigation has been proposed. But the larger system-wide issues that have been identified are a bigger conversation, and the county is going to continue to work with the city on some of these. We've already been in conversation with the city. We will be updating our county transportation system plan in the next several years, and absolutely am going to try to incorporate some of these bigger issues into that. For this specific purpose, though, we really need to focus on the actual, sometimes narrow criteria for the zone change. And so I would encourage the hearings officer to focus on those specific criteria. And I guess along those same lines, I understand and agree that this proposal doesn't qualify as needed housing as is specifically identified under the statute, but I don't also think that it's relevant. That's not one of the criteria. There's no requirement for the housing to be needed housing. I think arguably any housing is needed right now. If you look at some of the direction coming out of the governor's office, the production of housing is definitely a priority. But again, it's not a criteria in this case. And I'll leave it at that.
Thank you.
Yeah, I don't have much to add. I think Martha addressed everything well, and most of the comments were related to the zone change. One thing to note, just Mr. Andrew noted some drainage concerns. Those were addressed in 1006, and yeah, the county development engineering will review stormwater management plan, and there are ZDO criteria addressing that about discharge to adjoining properties, and those would be addressed, by the development engineering team at the time of development permit. The only other thing, and Mr. Cox, this may be on your radar, but it looks like we have I think 3 county development and traffic engineering staff, and I just wanted to see if any of those folks had any other follow-up items or anything to address, if that's appropriate.
Certainly.
Can't get with county engineer. I could start off with just kind of getting back to the original question of that the applicant raised of proportionality with the realignment of the Wilson intersection with Beaver Creek Road. And I think, as Martha mentioned, also we're looking with the zoning criteria, we're looking at the safety of the transportation system is adequate or not, or whether it is. And what county engineer has sort of stated at the beginning of the hearing is that there are safety issues with that skew whenever an intersection is not at or close to 90 degrees, that there is a safety issue, and that's why the road standards do have that standard in place. And as currently recommended for approval, it includes a mitigation to realign the intersection at or close to that 90 degrees. And I know the question of proportionality was raised, but without that particular mitigation, sort of county engineering or the county is not in a position to recommend approval of the subdivision zone change without that mitigation being in place. And I know that's something where we're talking about the open record. There'll be additional information to elaborate on. But that was the main item that I could address. There's some additional traffic questions, or Christian or Joe Merrick want to respond, but I know there were some comments on site distance, I think mentioned in the vicinity of this project site. At least the traffic impact study is evaluated that intersection with Beaver Creek Road. It did show that it meets site distance. So at that point, intersection site distance is meeting the current standards based on the posted speed of 45 miles. In terms of sort of bicycle improvements, or at least addressing that. At least for this project, they will be meeting that standard along the frontage. They'll be widening Beaver Creek Road and constructing bike lanes. But within the context of the subdivision development, it doesn't extend beyond the frontage, but they will be at least meeting that requirement with improvement of their frontage.
Thank you.
Sure.
Did you indicate Mr. Snuffin was going to also make a comment?
I will reserve my comments for the open record period.
Okay, thank you, sir. Does the applicant have rebuttal that the applicant wants to submit or make now? And as I indicated, the applicant can submit that during what we'll talk about for an open record period.
Yeah, we have.
Yes, thank you.
Yeah, this is John Rogus with AKS Engineering, the project engineer. Address is 12965 Southwest Herman Road, Suite 100, Tualatin, Oregon 97062. Wanted to rebut a little bit of Elizabeth, Tammy, and Norman's testimony there. Kind of want to just reiterate what Kent mentioned, that Beaver Creek Road, as shown in our plan sheet P19, I'm not sure the exact sheet of our application, but it's plan sheet P19 in the preliminary plans. Beaver Creek Road will have along our project frontage bike lanes. It's an 8-foot bike lane, so that complies with the roadway standards. And we're putting it on our side as we're doing half street improvements, as was previously mentioned. Want to talk about some other improvements that were mentioned as being needed along Beaver Creek Road. Anything outside of the project frontage would be kind of a requirement of Clackamas County, or a need for Clackamas County to improve if they found safety issues along Beaver Creek Road and or any other roads in this vicinity that are outside of our project frontage. That wouldn't be the responsibility of this subdivision and zone change application. So to the extent that any other improvements are needed, that would be Clackamas County would be needed to do that. I want to touch really quick on the drainage issues. This is also touched upon with Ben. The drainage would be required to be submitted to Clackamas County, the stormwater service provider there. And we do have in our application the preliminary statement of feasibility signed by Clackamas County that adequate surface water management, treatment, and conveyance is available to serve the development, or can be made available through improvements. So this will be evaluated in more depth in our final stormwater report that will be submitted to Clackamas County and reviewed and ultimately approved by Clackamas County. That's all.
Mr. Hearings Officer, this is Andrew Stamp for the record. I had a few issues that I wanted to talk about in rebuttal. I'll try to be really fast. First, with regards to the issue of proportionality, I heard transportation staff say, well, we got these criteria and we identified some safety issues, and we may not be prepared to recommend approval without the mitigation package we suggested. So a couple things to clarify. The law of takings in America has changed rather dramatically in the last 10 years. And so you get a lot of these old school planners and engineers who are kind of used to the good old days when they would simply, like when I started 25 years ago, the threat was, hey, you either build our improvements or we're going to deny you. And the law wasn't very clear on that. And so a lot of times that worked, the developer would just kind of eat it. And that game does not work anymore. There's been a fundamental shift in takings law. Dolan applies to denials as well as it does to approvals. And so you have to show the proportionality or you waive the standard. And you think, well, there's a safety problem. Well, it's not our safety problem. It's the community safety problem. So the community has to fix it. I will note that this project hasn't been on the TSP. So if it was a safety problem, Why isn't it on the TSP? Why isn't it on the STC CIP? Who's supposed to be doing that work, and why haven't they done their job? So when I see these types of things, what I see is it's not really a safety problem, but we're going to say it's a safety problem as long as we get someone to pay for it for free. That's just not how it works anymore. There's a new sheriff in town, called the Constitution, can't play that game anymore. I will cite you to the cases, but right now, just you can jot them down and take a look at them. Look at Brown versus City of Medford and Hill versus City of Portland. Those are two Oregon state cases that have acknowledged the new federal revival of the Fifth Amendment. Now, I heard a lot of talk about, well, safety. You know, a lot of this sounds like what the solution here is to lower the speed limit on this road. From what I'm hearing, if it's really dangerous, if people shouldn't be riding horses on it and driving bikes, that just sounds like the speed limit's too high. So that's an easy solution that doesn't cost anyone any money other than the cost of put a new sign up. I heard some talk about drainage. We will obviously comply with whatever drainage standards are applicable that the Clackamas County has deemed to be legislative appropriate. I will say under Oregon drainage law, the upper landowner has a right to put water into natural drainage channels. And so to the extent that downstream culverts are too small, that's not generally the problem of the upstream landowner. The generally accepted thing is that, hey, if you've got a bottleneck on your right of way, that's the county's problem. They need to put bigger culverts in. If you've got something on your property that's creating a bottleneck, you need to improve your drainage to accept that water from the upper landowner. That's Oregon drainage law.
Wait a second. I think it means, the way I read it is that the development can't make the drainage problem worse than it already is.
Who's that speaking? I didn't understand. I didn't see who that was.
This is Carl Cox.
That's not a correct rendition of Oregon drainage law. I would cite you to the case of Gabarino versus Van Cleve and Levin versus City of Salem, which creates the reasonableness standard. I can also send you a pretty big paper that I wrote, 50 pages on this topic. But the important thing is that we are going to comply with your county's drainage standards, but I'm just explaining what Oregon drainage law is, which is all common law. There's 75 cases that form the body of Oregon drainage law. And there's absolutely nothing in Oregon drainage law says that you can't make the drainage worse for downstream owners. I mean, that's just flat out. Okay. I want to address DLCDs because I think DLCD, at least as explained today, does not have a fundamentally correct understanding of the goals and how they apply. I went through that already in great detail. I didn't see DLCD cite to anything other than their own opinion, which is wrong. But when you have a zone change that is within the boundaries of what the comprehensive plan allows and has criteria for, that is, you don't get to the goals. And she says, well, the code doesn't explain when you need a goal 14 exception or not. Well, that would have been a nice thing for DLC to review whenever the county got acknowledged, but they didn't mention it then, probably because they knew that that wasn't the law at the time. So, but the bottom line is the comprehensive plan is acknowledged, and that's really the beginning and end of that discussion. What matters is they have criteria from going from one rural residential zone to another. DLCD fundamental position in this case is that you can't do any zone change from RFF5 to RA2 without a goal 14 exception. What they're not saying is that, of course, you would never get a Goal 14 exception because the criteria for an exception wouldn't allow any kind of Goal 14 exception. So when they say you need a goal exception, what they're really saying is you can't do it. Now, but if their rules really mean that you can never do a zone change from RFF5 to RA2, I could think of a heck of a lot easier ways to word the administrative rule than the way they worded it. You could just say you can't rezone from one rural residential zone to another. That would be all you'd need to say. But that's not the way the rules are written. And I'll be the first to tell you that the rules aren't written very clearly, but they certainly didn't write them the way that DLCD is hoping to interpret them today. That's really all I want to talk about. I know that Ms. Glazer-Lindsley raised a lot of points. My understanding is that all those points are in her memo, and we'll go ahead and address those during the open record period, unless there's anything that you want us to deal with right now. I think there was a lot of technical arguments made, but I think the problem with a lot of those arguments is that she's raising standards that are not mandatory approval criterion for a zone change. For example, she said, well, you have this roadway safety audit that recommended certain things, and the only way to prove that it's safe is to do the things in the audit. The roadway safety audit is not a mandatory approval standard, so that has not been incorporated into the comp plan or the zoning code, so that wouldn't apply. But anyway, I could go out ad nauseum about those things, but I will do it in writing instead.
Okay. And let's talk about the open record period. So I did receive a request to keep the record open. There's a statement I'll make about doing so. And I actually read a statement. Does any party or member of the audience want an opportunity to provide additional evidence, arguments, or testimony? And then does the applicant wish to waive the period for final written argument? I'm going to assume, since I've already received a request to keep the record open, that it will stay open for a
Yes. Yeah. Oh, did we just lose the hearings officer?
Oh, no.
Followed by a minimum of a 7 will not. What? No, I can hear you.
We can't
Hello.
hear you.
And I can see.
You keep breaking up.
Sort this out. Hang on.
We can hear you now, Carl.
Oh, open
Yep.
record period.
Yep.
A minimum of 7 days is a request for a longer period for the initial open record period.
Are we hot?
Yeah.
Mr. Hearings Officer,
Yes.
We've heard a lot of testimony. I'm a little bit worried about our ability to address it in a thorough and professional way in 1 week. I would think 3 weeks would be more appropriate, and I'm guessing that transportation staff probably also wants some time to develop their Dolan findings, their proportionality findings, so they probably would like 3 weeks as well, I'm guessing. So that would be my first request, and then to have either 1 or 2 weeks for rebuttal, and then have a final applicant-only final argument with no evidence.
What's the county's statement about a 3-week initial period? We do have some time here.
I'm sorry, I didn't hear what you said.
What's the county's view of an initial open record period of 3 weeks?
I think from my perspective that's fine. We also do need to consult with county council on this issue.
Okay, so, and then a second period, a rebuttal period, is 7 days enough?
I think so.
Yeah.
Okay, so we have 21 with that period closing at 4 p.m., followed by 7 days, followed by 7 days. What are those dates?
Let's look at
The first date, the 3-week closing period would be March 7th at 4 p.m. 7 days after that would be March 14th at 4 p.m. And final comment from the applicant only would be due by March 21st at 4 p.m.
Did everyone get those dates and times? Again, I for my stable, and I will be looking for a second connection that I can start as a backup. The initial period, new evidence, new test bone evidence included. That second period should be rebuttal only, no new evidence in the rebuttal, just a rebuttal of evidence submitted during that initial open record period, with a third open record period as described that is only a last word period for the applicant.
Mr. Hearings
Thank
Officer,
you
one
all.
point,
With that, I will
Hearings Officer, one point of clarification, please. The first open record period, you said new evidence, presumably on any topic, presumably raising new issues as well. But then you said surrebuttal would be rebuttal evidence only, and you said no new evidence. Do you mean that you could put new evidence so long as it responds to the issue raised in the first open record period, but not raise new evidence on new issues that are unrelated to what was submitted the first time? Is that what I'm understanding?
Yes, you can add legal argument or something of that nature to rebut evidence that's submitted during the first period. And you're correct. To clarify, your argument can be complete. You can provide supporting evidence to support your rebuttal. That's correct. I misspoke.
Okay, great. I will assume that the definitions in ORS 197-797 sub 8 will be used for that purpose.
I will review that and I'll make sure that I do.
Okay. That statute defines evidence and argument for purposes of these hearings. So
the land use statute.
Yes, 197-797 sub 8, I think. Maybe it's sub 9. I can't remember exactly, but right in there, it has a definition of argument, has a definition of evidence, and I think those are the ones that we'd apply here.
That's what I want to see. Yes.
Okay.
Thank you.
Thank you.
And we're talking relevant evidence is also what I'm talking about. Relevant to the approval criteria, and same with the rebuttal. All right.
Okay.
With that, I'll close this hearing, and I'll look for the additional submittals during the open record. Thank you all.
Thank you.
And I appreciate your patience with my connections.
Thank you.
Thank you.